Good afternoon, everybody. I hope you all had a great Victoria Day weekend. My name is Gregory Smolinek, and I'm the Deputy Commissioner of Privacy at the Office of the Privacy Commissioner of Canada. And in my portfolio, I have privacy promotion and privacy policy. Today, I'm going to talk to you a little bit about privacy in the time of pandemic. And I'll let you know what we in the OPC have been doing for the last few months. I'd like to start, however, by thanking the Ryerson Leadership Lab and Rogers Cybersecure Catalyst for bringing us together to exchange ideas on the important issue of protecting fundamental rights to privacy in these times. I've been in my job since August of 2018. Prior to that, I worked in the Department of National Defense. From the time I arrived at the OPC, and I expect even before I got there, it's been a very busy place. It's certainly a happening place to work. And as you all are aware, privacy has been in the headlines around the world, including in Canada. Here in Canada, we've had major investigations. And just to name a few, I could name off Equifax, Facebook, Cambridge Analytica, and more recently, StatsCan. And these are only some of the more prominent cases that we've investigated since I started. And of course, around the globe, privacy has been an ever expanding concern, and we've had the introduction of new laws in different jurisdictions, as you're all aware, with the GDPR in Europe and the California Consumer Privacy Act in the United States, just to name two more important new statutes in different jurisdictions. In Canada, my office has been calling for serious privacy reform for a while now. We've been calling for updates to the Privacy Act that governs privacy in federal institutions, and to PIPEDA, the private sector law that governs privacy among commercial entities. In our view, both of these acts are now woefully out of date. In fact, law reform has been the focus of my efforts since I started just over a year and a half ago. Now the pandemic has brought forward privacy issues in new and unexpected ways. The central theme of the OPC in 2019 was that we had reached in society a critical tipping point upon which privacy rights and democratic values were at stake, and that we in Canada needed to reform our privacy laws to put them on a rights-based foundation, along with giving the regulators, such as the OPC, effective enforcement mechanisms. As 2020 began, it looked like the government might indeed start the process of updating PIPEDA. There were hopeful signs. Of course, then the pandemic hit, and it has, understandably, seriously affected the legislative agenda of the federal government. But the pandemic has also foregrounded important privacy issues, this time in the context of issues such as contact tracing, other pandemic surveillance measures, and also with the expansion of online and remote networking. In fact, what we're seeing is an accelerated digitization of social interaction, of the workplace in this new context. So if the digitization of society before the pandemic was epochal, then so too are the vast impacts of the pandemic on the economy, culture, science, on individuals, and society writ large now. We have, I believe, arrived at a moment in time that is a transformational moment in history. And I think it's reminiscent, at least in recent comparisons, to the time after the Second World War that called for major societal transformation and responses, policy responses that were adequate to the situation the country faced. I think we're at such a moment with this accelerated digitization and the pandemic context. What I have in mind is a societal transformation that recompasses a rededication to the ideal that Canadians will continue to build and sustain a democratic community of free but mutually obligated individuals, united in cooperation, but without uniformity. And in this vision, among other important social, economic, cultural, and scientific measures, protecting human rights, including the right to privacy of Canadians, is central. Today marks the 63rd day that the Office of the Privacy Commissioner of Canada has been teleworking. It also marks the first time I've put on a blazer in that time. We started teleworking on March 13th, and in fact, we've been kind of lucky in the sense that almost all of our staff was equipped with mobile devices and tablets, and we had a secure VPN connection that allowed us to connect securely to OPC networks from remote locations. So really, we didn't miss a beat in transitioning to teleworking. In fact, we've been busier than ever, not least because of the many privacy issues that have resulted from the pandemic. We understand that limiting the spread of COVID-19 is an urgent and unprecedented challenge for governments and public health authorities. And it's therefore not surprising that governments are looking for ways to use personal information and big data as part of their efforts to stop the spread of the virus. Some initiatives, however, are creating significant privacy risks for privacy rights in Canada and around the globe. Our office recognizes that COVID-19 is a rapidly evolving public health situation that requires swift and effective responses. We also recognize that the right to privacy is not absolute. It exists alongside other rights and must be considered in a broader context that takes into account other interests, such as public health, of course. Nevertheless, even in a crisis, the privacy laws still apply. I'll focus my remarks on how it's possible to ensure that we achieve both privacy and public health goals. Technologies that rely on the collection and use of personal information can be part of the solution to fighting the pandemic. The key, in our view, is proper design. Initiatives should be designed with key privacy principles in mind. Before I proceed to an overview of our pandemic-related work, it might be helpful for me just to outline briefly what the OPC is and what it does. As many of you are no doubt aware, the Privacy Commissioner of Canada, currently Danielle Townhall, is what's known as an agent of Parliament. Agents of Parliament report to Parliament. They're not part of the Government of Canada, not part of the executive. Commissioner Therrien, unlike deputy ministers and line departments, does not report to the Prime Minister nor to a minister. He is not responsible for carrying out the priorities of the government of the day, nor is he an officer of Parliament, such as the Sergeant at Arms or the Clerk of Parliament, whose jobs are to help manage the proceedings of Parliament. The mandate of the Privacy Commissioner and his office is to protect the privacy rights of Canadians within the legislative framework provided by the Privacy Act and PIPEDA. The OPC investigates complaints and promotes privacy rights. And the OPC also provides advice and information for individuals, as well as government departments and the private sector, on how to be compliant with the law and how to better protect personal information. As I mentioned, we're operating at full tilt. Everyone in the office is working remotely, and it's going surprisingly well. Our bread and butter work investigating complaints is continuing, although with a recourse to remote teleworking arrangements. But much of our collective effort has shifted now to working to support good privacy decision-making in the context of the pandemic. We've developed a few guidance documents and are responding to numerous questions and requests for advice, both from the government side and from the private sector, as they develop programs and take initiatives to manage the pandemic and its effects. In March, we issued guidance to help organizations subject to federal privacy laws to better understand their privacy-related obligations during the pandemic. We followed up in April with a privacy principles framework to support the Government of Canada in assessing COVID-19 related initiatives and their impact on privacy. This policy document aims to guide the development of these initiatives in such a way that they respect privacy rights to the maximum extent. Both the guidance and the framework are available online at the OPC website. A couple of weeks ago, along with our provincial and territorial counterparts, we issued a joint statement on privacy and contact tracing applications. Given the importance of privacy risks related to these types of applications, we felt it important to provide a common message on how privacy should be protected as these apps are rolled out. The joint statement notes that existing privacy laws are outdated and don't provide effective protections in digital environments. Pardon me. Therefore, we called on governments to at least respect certain principles in their design, and especially in contact tracing applications. I should mention that we're also in contact with our international counterparts who are seized with the same sorts of issues in their own countries. We formed an international COVID task force within the Global Privacy Assembly, that's the International Conference of Privacy Commissioners, to exchange information and best practices. And we've also been extremely busy responding to urgent consultations from government departments that are launching all kinds of pandemic-related programs, health programs, but also economic programs with lightning speed. We've been advising the government on how to do so in the most privacy protective ways possible. That's an overview of what we've been doing. I'll now shift to a short discussion of the general approach we're taking, our philosophy, so to speak. Underlying all of our office's guidance is the recognition that the pandemic calls for a flexible and contextual application of privacy laws. In times of crisis, certain measures may be justified under the circumstances to protect the health and safety of Canadians. During one of his daily news conferences late last month, the Prime Minister was discussing the use of contact tracing apps and noted that we need to make sure that privacy is respected, even in the time of emergency. Clearly, that's our view as well, and we welcomed his message on privacy and contact tracing. As I said a moment ago, in times of privacy, privacy laws can be applied flexibly and contextually, but they still must be applied. Privacy is a fundamental human right, and therefore, basic privacy principles continue to apply and are extremely important in a democracy, especially at a time of crisis. In our discussions with federal government departments and other organizations, our office has emphasized that certain key privacy principles should continue to factor into any assessment of measures proposed to combat COVID-19, especially those that are at higher risk for privacy infringements. The framework we issued in April supports these discussions. It presents our expectations in a pared down way, more targeted way, while providing an important analytical tool that helps establish what those principles are and how they can be applied. The key principles are described in some detail in our framework, but I'll spend a few moments going over them. The first is legal authority. All organizations must continue to operate with lawful authority, and they need to identify the legal authorities that are being used to collect, use, and disclose personal information. It's also very important that the governments ensure transparency and accountability. They need to be clear about the basis and terms applicable to exceptional measures, and they have to be accountable for it. In my view, one of the more important principles is the purpose limitation principle. Personal information collected must be used to protect public health and to counter the pandemic, and for no other purposes. This means, for instance, that if you download a contact tracing app in order to help with public health efforts, the data the app collects about you cannot be used later for commercial purposes or for general state surveillance purposes unrelated to public health. Whenever possible, de-identified or aggregate data should be used. Seeking consent is clearly the approach from a privacy perspective, and consent should be meaningful. Health data is sensitive, personal information, and that means collection must be based on express consent. Another super important measure is necessity and proportionality. This means, for example, that an initiative that impacts on privacy needs to be science-based and necessary to achieve a specific identified purpose. In other words, public health purposes underlying a potentially privacy infringing measure must be based on scientific evidence and defined with some specificity. It's not enough simply to state that a measure supports private health without being public health without being more precise. And it's not good enough to say that some measures, for instance, make people feel comfortable, when in fact there is no necessary public health reason for using it. In fact, there may be some measures that are ineffective, provide a false sense of security, and therefore may potentially increase the risk of contagion, while at the same time are needlessly invasive of privacy. Necessary, however, doesn't mean potentially useful, nor does it mean absolutely necessary. it does mean that an initiative has to have evidence behind it and is likely to be effective and needs to be assessed in this context. Necessity and proportionality are clearly important considerations in the context of contact tracing ads. We've heard a number of questions raised about their effectiveness, and we need to keep that in mind. For example, about contact tracing ads, they require a very significant portion of the population to use the app for them to be effective. There are also concerns about false positives, as the technology powering these services, for instance, Bluetooth technologies, they have a larger range or a wider range than recommended for social distancing spacing. So signals may pass through walls, leading someone to be identified as being in contact with an infected person, when in fact, they may have never been in the same room. You've also probably heard that some organizations, such as retailers and employers, are looking to put in place temperature checks as screening measures at front doors to determine who can enter establishments. Temperature checks involve the collection of sensitive personal information. Therefore, we'd expect that any organization that launches such an initiative, that it would ensure that this is necessary, proportionate, and in accordance with direction and guidance from public health authorities. Here, I would note and stress that Dr. Theresa Tam, Canada's Chief Public Health Officer, has said that temperature checks on their own are not effective. Finally, one more key privacy principle that's important to consider during the pandemic is that exceptional measures should be time limited. Privacy intrusive initiatives should end, and the data collected during this period should be destroyed once the pandemic is over. Key lesson from 9/11 is that it's important to ensure that measures introduced during a crisis do not endure for years and years long after the crisis ends. One of the reasons we initially decided to develop the Privacy Principles framework was to help fill the gaps in current federal privacy laws. The COVID-19 crisis is highlighting shortcomings in our legal framework, and it has strengthened arguments for a rights-based approach to privacy law reform. In failing to recognize privacy explicitly in a comprehensive way in the statutes as a fundamental human right, we face the risk that privacy will not be given appropriate consideration in discussions about how best to respond to crises such as a pandemic. Currently, not all fundamental privacy principles are enshrined in law, meaning that their application is not guaranteed. In our view, there needs to be legal assurance that basic privacy principles will be followed, particularly to prevent any lasting infringement after a crisis is over. Some key principles that ensure respect for privacy as a fundamental right need to be elevated to the status of law to ensure that there is appropriate recognition and protection of privacy. Commissioner Carrier set out a detailed blueprint for modernizing federal laws in our last annual report to Parliament. Because data-driven technologies have been shown sometimes to be harmful to privacy and other rights, our office's view is that the starting point for law reform should be to give privacy a rights-based foundation. Current federal laws have been in urgent need of modernization for a long time. Even at the best of times, they're not up to the task of protecting Canadians. During a time of crisis, the risks related to deficiencies in the laws are even higher. We should all be concerned that current laws leave open the potential for COVID-related technologies to be designed without consideration of all important privacy principles. The situation creates a range of potential risks for Canadians. For example, there are many gaps in terms of organizations that are covered by privacy laws or not covered by privacy laws. One scenario would be for a government to partner with an organization that's not involved in commercial activities and is therefore not subject to any federal privacy law. Inadequate legal protections also leave open the risk of government collaborating with a commercial entity that uses personal information not only for public health purposes, but for commercial purposes as well, and could potentially sell the personal health data collected. Of course, these things are not necessarily happening. They need not necessarily happen. But Canadians shouldn't have to worry about these kinds of things, or even a possibility, because of deficiencies in the privacy laws. And here's an important point. Good privacy laws are a key to promoting trust in both government and in commercial activities. And trust has been lacking in society for a while now, even before the pandemic. In fact, trust is a key element in democracy and democratic governance. It's key to economic growth and commercial activities. And trust is also key to good public health management and economic recovery in the context of the pandemic. And privacy is key to trust. Long before the pandemic turned our lives upside down, our goal was to advocate for proposals to strengthen Canada's privacy laws in a way that would establish democratic conditions for responsible innovations that serve the public good. Rights-based laws are not an impediment in any way to innovation or to effective responses to public health crises. On the contrary, they help build trust in public health, trust in democracy and democratic institutions, trust in commerce, and trust in, especially importantly, in your fellow citizens. And all these things ultimately serve the public good. That's basically what I had to say today. I thank you very much for your attention. Under different circumstances, I would have much preferred to be in the same room as all of you. I look forward to maybe sometime in the not too distant future to have a less socially distant conversation with you. And I hope I've given you a sense of what the OPC has been up to recently and a sense of how we're trying to make a positive contribution in the national discussion about how to confront and overcome the pandemic. I'm looking forward to any questions you might have or comments. So I'll hand it over now to Kareem, and we'll carry on with the discussion.
Thank you very much, Gregory, and thank you for bearing with us while we had some technical challenges there at the beginning. My name is Kareem Bardia. I'm the co-founder and executive director of the Ryerson Leadership Lab, and I'll do a few preliminary comments about us and about this work before we get back to Gregory's presentation and some of the questions that are raised by it. So this is the sixth in our series of virtual town halls on cybersecurity and digital privacy in the time of COVID-19, and we're honored to have Gregory Smolenick join us today and lay out some of the thinking that the office has developed and some of the work it's already done with respect to this issue. This series is part of the new Cybersecure Policy Exchange project between the Ryerson Leadership Lab and Rogers Cybersecure Catalyst. Cybersecure Catalyst is a center for excellence in cybersecurity at Ryerson, based in Brampton. They deliver a number of training, R&D, and commercial acceleration activities, including a program especially for new Canadians, women, and displaced workers, and many of them are joined us in this town hall as well. This project is offered thanks to the generous support of RBC, and it's really about advancing effective and innovative public policy in cybersecurity and digital privacy more generally. And a number of policy issues that Gregory has laid out are clearly very pressing as part of that work. Also want to acknowledge the people who are able to participate in this video town hall and many others who maybe would have liked to but aren't able to because of their pressing needs around work, around childcare, or around other activities. So I honor and respect those who've been able to participate under constrained circumstances, including, of course, our guest, Mr. Smolenick, and those who are not able to participate. Also wanted to, as part of that acknowledgement and recognition of who's participating and where we're participating, I want to give an acknowledgement of the land that I'm on and that Ryerson sits on, which is the territory of the Anishinaabe, the Haudenosaunee, and the Huron-Wendat. Ryerson is covered by the Dish with One Spoon Treaty, Treaty 13, and the Williams Treaties. And we're committed to honoring our obligations to those nations, treaties, and to justice for Indigenous peoples more generally. As part of this project, and perhaps it's something that we might be able to get into a bit in this discussion, we hope to do that by taking seriously the differences that Indigenous peoples experience through technology. We had a rich discussion at our last video town hall, which was focused on the digital divide, about how the impacts of technology can be felt more acutely by Indigenous peoples. And we want to ensure that as we look at the privacy and security risks and impacts of the way forward from COVID-19, that we keep that lens on everything we do. And we might be able to get into a bit in that discussion. I invite participants to, as you've seen in the chat box as well, go to slido.com, use the event code cyber privacy to put your questions. And I believe there's some questions already there. And I will be asking those questions on your behalf, as well as putting some directly to Gregory. So Gregory, you laid out, I think, really helpfully what your office is and does, and how it's works directly through Parliament and not for the government directly, but on behalf of the people of Canada through Parliament. And a number of really important points that you laid out, including some assumptions I think that Canadians have around what the rights or what the legal regime might be around our right to privacy at this time. So can you just say a bit more about where that right to privacy comes from? Is it in our Constitution? Is it kind of been read into our Constitution? And what powers that you have to enforce the rights as you understand them at a time like this?
So privacy is considered widely in Canada and internationally as a human right. Article 12 of the UN Declaration of International Human Rights, which is now just over 76 years old, explicitly lists privacy as a human right, part of the UN Declaration, and Canada is a signatory to the UN Declaration. In fact, the Declaration itself has a Canadian angle to it. John Humphreys, a McGill Law professor, was the author of the UN Declaration. So there are, if you will, there's Canadian authorship in that recognition of privacy as a human right. There are other international conventions also which establish privacy as a human right. In our statutes, there is reference to a right to privacy. Our goal is to enhance the prominence of the view of privacy as a human right by more explicitly providing, well, in our recommendation is to provide a preamble to our renewed statutes, updated statutes, so that privacy is more explicitly considered a human right. And it would also provide a basis for interpretation of the rest of the statute. So we still believe that the statutes could be technology neutral, for instance. And our laws do have a lot to commend them. The problem is, however, that the Privacy Act, which was promulgated in 1983, and PIPEDA, the private sector law, which came into effect 20 years ago, all predate modern digital platforms, the internet, etc. So, well, not the internet for PIPEDA, but you know, the growth of online social interaction, online commerce, etc. And they desperately require updating. The Rights-Based Foundation, I think, will be a very helpful way of providing the right context in which privacy rights are interpreted in the context, for instance, of commerce or government operations. Further to your question, privacy is considered to be a quasi-constitutional right. So there are aspects of the Charter of Rights and Freedoms in Canada that are connected to privacy, even if there are no explicit references to privacy in the Charter. So it's not especially controversial in Canada to talk about privacy as a fundamental human right. On the other hand, it puts into the proper context what privacy means in different social interactions, such as commercial interactions. I think it would really, really help Canadians and certainly protect their privacy if this explicit rights-based foundation was recognized as law.
Thank you, Gregory. And I think a lot of the framework of this conversation might need to be informed through that understanding of the legal foundations. You had mentioned that Commissioner Therrien had put together quite a comprehensive series of recommendations to government and to Parliament, rather. We're seeing emergency legislation being tabled now to deal with various responses to the pandemic. Do you see any prospect of the pieces that you've put forward being taken up by government and being proposed as legislation in the context of this emergency, or will that have to wait?
So as the emergency continues, I think the prospects for serious law reform are going to get stronger. what I see happening, for instance, in the United States, is that there are several congressional initiatives in the US explicitly because of the pandemic calling for new US federal legislation to address privacy in the context of the pandemic. We're also seeing that a lot of Canadians are indeed concerned about their privacy rights, even in the context of the pandemic, and they want to be sure that their privacy is protected if, for instance, they use contact tracing ads. So I don't think the privacy discourses have been derailed entirely. They might be, to use an academic term, being reinscribed by the pandemic a little bit. And I think that there is a widespread recognition, and I think there was some recognition of this before the pandemic, that this trust issue that I spoke about, the trust, there's trust in democratic institutions or trust in commerce, there's a privacy dimension to that. And now we're seeing that people need to be able to trust in public health authority guidance, for instance, if the economy is to be reopened successfully. So people have to have some measure of confidence. Now, privacy, don't get me wrong, privacy is not the sole consideration in all aspects of trust or in public health guidance, but it is an important dimension. And I think if people can rely on different measures that their privacy is going to be protected, that only helps to shore up trust in various institutions, private and public. So I don't think it's going away. I don't know what the prospects are or the timings are, but I think that we will see once again privacy reemerge when, I don't know, on the legislative agenda in Canada. You know what? In truth, I can't actually confirm that it is necessarily off the agenda, such as it is. But of course, the government's attending on a daily basis to important and more urgent pandemic issues. But so I think there's hope, and I think there's absolutely need for this. The other thing I would add to this this issue is that Canada, compared to other jurisdictions, the federal government compared to provinces, is behind in legislative or statutory terms. Compared to Europe, we're behind. Compared to other jurisdictions, we're behind. There have been important and more rigorous privacy laws introduced in various jurisdictions around the world. If once upon a time in the distant past, in the previous millennium, we were leaders in privacy in terms of our legislation, we're now laggards. And I think there's a recognition of this. And I believe that at some point in time, a Canadian federal government will take action to rectify this and update our laws.
So, and we're starting to see at least discussion of contact tracing regimes being rolled out, and specific contact tracing technologies, phone-enabled technologies rolling out. It sounds like there's a definite possibility that legislation won't be tabled to catch up. So, what tools do you have at your disposal? You've already given kind of official public guidance on a principles basis that you referred to earlier. What tools do you have available to you to make sure that the public interest is protected as these roll out in the absence of legislation?
Well, I have to say that so far we have been, by certain parties, consulted on contact tracing. We've also put out this public statement along with provincial and territorial privacy commissioners on what we recommend to see in contact tracing developers and from governments. Tools. We have the same tools that are provided for by the extant statutes. We can investigate complaints, right? So if there are Canadians who complain about certain initiatives or measures, pandemic related or anything, we will investigate those complaints. I have to point out, have been encouraging private entities, but also federal institutions to consult us. We do provide formalized advisory services to both federal departments and private institutions. In some cases, those offers of advice have been taken up. And when there are good faith interactions from either private sector developers or from government departments, which is often the case. We see like a good interaction, which introduces different privacy design measures into various either government programs or apps or whatever is at issue. So we have the traditional long-standing tools that we have given by those current statutes. Among the problems with the current statutes, however, is the Office of the Privacy Commissioner does not have the enforcement powers that some of our provincial counterparts have or that our international counterparts have. So basically, we cannot make orders. This is different from other privacy commissioners in different jurisdictions. We cannot administer monetary penalties. So there are lots of things that are pretty standard in the Data Protection Authority and Privacy Commissioner world internationally and in Canada that we don't have. So that's another thing we're looking for in law reform measures to sort of bring us up to par with our international and some of our provincial counterparts so that we could more effectively enforce the privacy laws. The thing is too about this issue of enforcement powers, it's not that we're power hungry and eager to issue fines or to issue orders. The existence of those powers certainly encourages a priori compliance. You know, people are much more motivated to be compliant with the various aspects of law when they know that there are serious consequences. And that actually helps people, well, to maintain privacy rights before any problems arise. But even in the instance where there are transgressions or infringements of privacy laws, it helps remedy the situation more quickly. So if you can administer fines, for instance, or make an order, it could rectify the problem and resolve a person's rights infringement more quickly than if you have to take something to court in a drawn-out, multi-year litigation. So,
okay, that's great. Thank you for that, and thank you for reminding us of the regime, the system in which this takes place. A question I think a lot of Canadians have, and this is on the top of the list on Slido currently, as well as of the things you're seeing out there right now, and it could be things that you're hearing about that could be in the news media that aren't necessarily being tabled as official complaints through to your office or the Office of the Privacy Commissioner. What's the most worrisome infringement or practice that you're seeing out there, either by a government or by some private actor, that you would really want us to be aware of right now?
Are you asking about current pandemic related?
Yes, exactly.
I'd have to say that, well, we could see the potential. So I have to distinguish. It's not necessarily that we're seeing any kind of major legal transgression right now. But what we see is that, let's say in the deployment of contact tracing apps, and by the way, we don't, just for the record, we don't certify or approve any particular apps beforehand. But as
assessments, you give where
advice. Yeah, we give advice.
Yeah.
But you can see there's a potential. So if a private entity were to develop an application, it could be contact tracing or another application that gathers a person's health information. There is the potential, and that this information may be, for instance, collected without full disclosure of the purposes for which it's being collected. It may be disclosed to third parties, for instance, for reasons or commercial purposes that aren't clear to the people from whom this personal information is being collected. I mean, these are the kinds of things that can happen anytime personal information is being collected. But right now you have a rush on an urgent basis of different entities seeking to collect personal information, ostensibly for good Samaritan purposes, but there is the risk always of the misuse of this information for other less altruistic purposes. So those are some of the things that we have our eye on. But this is, to be clear, potential activities and doesn't reflect necessarily any active cases or investigations.
Where a government or a company is collecting data and they are stating that it's for a given purpose, do they then disclose, how would I know that they're not doing it for another purpose? Do they have to make a proactive statement? So on a contact tracing app, do they have to tell me positively that they're only using it for a given purpose? And then is it up to them to self-enforce that they don't use it for those other purposes? Or do you have an ability to check on those claims that the data is only being used for a very narrow purpose?
So if somebody's collecting your personal, if commercial entities collecting your personal health information, this is considered to be sensitive personal information, and the mode of consent needs to be expressed. Like, it has to be clear, it has to be meaningful consent. Separate from the pandemic, we issued quite detailed guidance on what meaningful consent amounts to. That's also available on our website. In terms of enforcement or checks, this is another gap in existing legislation in the private sector. We have an audit power, but that audit power has a very high threshold to be triggered. We have to have reasonable grounds to believe that there's been a violation of the law. So reasonable grounds is actually a very high standard legally in order to conduct an audit. Higher than, for instance, reasonable grounds to suspect. It's quite a high bar indeed. That's very limiting. There would have to be a complaint, or there's also an option for what's known as a commissioner-initiated investigation. That's possible as well, but less common. So yes, the firms need to say what they're doing, and they need to be accountable as well.
And don't tell us anything that we shouldn't know, but are there any commissioner initiated investigations with respect to pandemic-related activities that are happening now?
I could say there are none.
Another question from Slido. What are some of the Office of the Privacy Commissioner's concerns about employee privacy in the era of teleworking?
So the question's about privacy and teleworking, generally? Okay. Well, we do have concerns, of course. Like, all of a sudden you have various teleconferences, meetings over various different corporate platforms for teleconferencing and video conferencing. Now, these not all these technologies have the same privacy standards. So we're monitoring and assessing different platforms. Those are some concerns. We have concerns both, just by way of example, applies to both private and public sector, but I'll refer first to the federal government entities. You know, federal government entities have policies on information security, for instance. So we have policies on protecting personal information. These policies, some of them were developed in, pre-teleworking eras, and involve things like, properly securing hard copies and cabinets with appropriate specifications on locks and these kind of things. Not all organizations have access to secure VPN. So there's all kinds of concerns about the handling of personal information online. One of the big concerns as well in the among federal organizations is that access to information and privacy units within federal institutions are often now, not all, but many are also teleworking. A lot of their systems and ways of doing their business, whether it's access to information or privacy, revolves around old school hard copy methods. So they actually have a lot of trouble, not all organizations, but many have a lot of trouble working digitally and remotely, which is gumming up the ATIP world in the federal government. This needs to be addressed. The private sector organizations face similar problems or analogous problems in that when they're handling personal information, there may be different means now outside the office environment for networking and private organizations need to take into account what are the systems they're using, are they secure, is the information safeguarded over these remote network connections. These things are basic, but they're not always obvious. Or sorry, they may be obvious and basic, but they may be more difficult sometimes technically to implement, right? People, human nature may be to take shortcuts and, oh, I'll send an email over an insecure means because that's the only way I have of communicating. Our view is that's not good enough. You still are responsible for safeguarding the information no matter how you're communicating, and you can't just let fly with insecure means or over insecure platforms. So some comments.
And all of this, as you kind of alluded to, is happening at a quicker speed where the usual ability to check in on these things may be compromised, and people's own work may be compromised in a number of ways. So really important indications. Another question from the audience: as data is able to cross international borders so easily, how can we create domestic privacy policy regulations? Do we have to take an international approach? And then perhaps that's nowhere a bigger issue than in contact tracing, where we have this prospect of some multinationals, Google and Apple, coming together being the most well-known example. How can we create these regimes across borders, especially in an era where, in many cases, where data is housed is something that is a policy that might not be what Canadians would prefer.
These are big questions. They were big questions prior to the pandemic and may have become more urgent during this time. So, I mean, to state the one possible solution, and it may be viable for different organizations, is it possible, for instance, to store your information in Canada? Whether it's depending on the servers you're using, it is possible for organizations to have their own servers. They're different. We know of app developers who are explicitly looking at servers within Canada, amongst other reasons, for the reason of obviating the potential privacy risks of storage outside of Canada. There are cloud facilities in Canada as well that are potentially available. All of this necessitates careful looks at what the contractual obligations are related to storage, no matter where it is. So custodians of data need to make sure that they take a very, very close look, a close legal look at contracts, who they're working with, who processors are, where those processors are located, what the terms and conditions and contractual obligations are related to processing or storage. All critical at any time, but including now. And again, health information being sensitive information, it's very important to know what those provisions are. The other thing is there's a need for some measure of coordination interprovincially as well, right? So different privacy laws apply within Canada. There are provincial privacy laws as well, both health privacy, but also some similar private sector privacy regimes in some provinces. When the data is flowing across provincial boundaries, there are implications as well, including jurisdictionally, for who regulates that.
Are there at this time, there's lots of interest in specific technologies or even specific programs or companies that the specific companies' products. So I'm wondering, and I think a lot of people are wondering, again, you don't give a seal of endorsement necessarily, but do you have views on and would you be investigating or examining a product like Zoom? One of the questions from our audience. Zoom is barred from use by the Government of Canada Public Administration, but it's used by Parliament. So could you speak to that choice and to the way you look at individual technologies or individual products at a time like this?
So I have no comments to make specifically about Zoom, but generally speaking, we do have a technology watch function, right? So we do have one of the groups within my sector of the OPC. It's called the Technology Analysis Directorate, and we do try to keep up to speed with various technological innovations and so on. So even absent necessarily an investigation, just to be aware of technological evolution. One of the issues right now is, I'd say that the current laws, our PIPEDA private sector law, is very much complaint driven. So complaints drive investigations, and they also give little latitude to the OPC in terms of not accepting a complaint, basically. So there's a resource implication to that. We receive complaints about whatever, and this is not in reference to any firms mentioned in your question, but on whatever issue at any time, the complaints-driven system that we have kind of focuses our attention, whether or not that attention is merited in terms of, widespread privacy risk. So having some latitude in being able to audit, to proactively inspect would be very useful, and probably also more privacy protective in a global sense, because we'd be able to focus our attention on those things that are of greater and wider importance to people affected.
And again, at a fast-moving time, when you see things, use cases popping up and adapting in all kinds of surprising ways.
Yeah.
A number of questions, maybe drilling down a bit more on the worker side and the health data question. You mentioned the prospect of the taking of a temperature upon entering an establishment. I think a lot of workers are going to be facing various kinds of questions from their employers or their supervisors about their own personal health status as they go to work now or plan a return to work. Do you have any guidance on that? And how can employees protect themselves? What's a fair question to be asked, and what's not? And what recourse do I have from being asked those questions, either as a visitor of a retail establishment or a worker?
So I'll give you some thoughts on this question. I don't have a perfected total answer to this question, which is looming ever larger every passing day. But I'll give you some considerations. One consideration is that if somebody's establishing some kind of screening method at the entrance to some building, workplace, mode of transportation, for instance, all the usual things apply. And one of those usual things that we're asking organizations to apply are tests of purpose and necessity and proportionality. In the pandemic context, what we have seen, or what we're observing, is that the science has not necessarily paced the initiatives. So, I'm not an expert in serology or testing for antibodies, but it's, from what I understand about medical science of testing for antibodies, it is at present unclear whether people can develop immunity to COVID-19, how long that immunity might last, if there is immunity, what the character and amount of antibodies they have to be seen as immune. So there are all kinds of questions about antibodies, serology, and immune testing. The same goes for concepts that we've heard about more often in Europe and the United States than in Canada, about things like immunity passports. Mm-hmm. There are a whack of privacy issues related to these kind of ideas and these kind of concepts. But in the first instance, it's not even clear that these things are relevant, that they would work, privacy aside. But their efficacy, or their effectiveness rather, is central to the privacy question too. So with temperature checks, we've heard statements from the Public Health Agency of Canada, for instance, that on their own, temperature checks may not be effective means of screening for COVID. So the question then arises, let's say there's a commercial entity that wants to have some kind of thermal imaging that measures people's temperatures. Well, is that effective? Does it align with the advice of public health authorities? Or is it useless? So the question is, would it in any way be effective as a pandemic countermeasure to prevent the spread of the disease, which would be considered in the consideration of the privacy dimensions of the problem? Or is it ineffective and unhelpful? I can imagine circumstances, for instance, when somebody is going to put in place a some kind of temperature check, some kind of thermal imaging to allow for entry into, let's say, a retail space. And they set the temperature, like the fever level, so high as that they won't capture many people, right? So they, a lot of people who are maybe carriers of the virus do not have a fever at all. Some people might have a fever in a low range. And therefore, rather than maintain safe social distancing and other recommendations explicitly recommended by public health authorities, they say, well, these people don't have fevers above 38 or whatever number is given, and we'll admit them and overcrowd our retail space because that's a safe measure. In fact, you may have actually just created a public health problem. Now, I'm not a public health authority, and I'm not going to assess what the right temperature is or not. But one of the things is the measure should be evidence-based and should have a clear purpose, should be reasonable and clearly articulated and necessary to achieve the necessary purpose, right? But that's not clear. So sometimes the science lags some of the initiatives, and that's an important aspect.
It's a good warning about the concept of immunity passports generally. I'm wondering whether we would ever see, and we'll have to wrap up, could we ever see joint advice from the Privacy Commissioner and public health authorities, so that there was some sense that the trade-offs have been resolved, that some of the scientific questions have been resolved, and so a regime, whether it was contact tracing or some of the back-to-work provisions, could we ever see a day in which you were providing joint advice, or it could come in directly afterwards and give a comment?
I think, I mean, we do have a good working relationship with Health Canada, for instance, and with the Public Health Agency of Canada. I think among the things I'd say is we should always make sure that we're not contradicting public health authorities in any way, that our advice is consistent with the advice of public health authorities. We're encouraging public health authorities, however, to consult us on the privacy aspects of initiatives. And we encourage private entities and organizations and other federal government departments to adhere to both public health authorities and the advice of the Privacy Commissioner of Canada. So in this case, I think it's entirely possible to have our cake and eat it too, and to have both good public health protection and advice and privacy advice observed.
Thank you so much. That's a really hopeful, I guess, conclusion on a very fast-moving file, and one I know that you and your team are spending a lot of time on. Maybe could you, again, without revealing or selling any particular product, could you tell us what video conferencing product your own group uses? I don't know if there'll be any flocking to that after this, but
I have to say, and I kind of am happy about this, because I get to remain unshaven in my pajamas, and we teleconference by phone only. So the OPC has just audio teleconferences, and we have way too many of them, but I don't have to clean up for them.
Oh, that might be guidance many more of us should take for our various might benefit our health in various ways. So thank you for that as a parting comment. Deputy Commissioner Gregory Smolinek, Deputy Commissioner of Policy and Promotion in the Office of Privacy Commissioner of Canada. Thank you so much for your time, and we'll be following these. Watch for work from the Cybersecure Policy Exchange, specifically on the issue of contact tracing. To our audience, we've got new national research also coming out that we'll be publishing soon, and this project will also be doing more convening with subject matter experts and more public engagement forums like this one to help inform the policy community. So on behalf of Rogers Cybersecure Catalyst and Ryerson Leadership Lab, thank you so much for joining this conversation. Thank you, Deputy Commissioner Smolinek, and we look forward to continuing to follow this conversation. Any last comments?
For me, I wanted to say thank you for inviting me, and I really have to say I commend you all, for the organizers and the sponsors, for putting together this series. I'm really impressed by the number of speakers you've had and the audiences you're getting. So really super commendable set of talks. Thank you.
Thank you. And we'll be sending out a summary and a video of this for participants later on. And stay tuned for more in this series. Thank you so much.
Thanks, Kareem.